You may be seated. Thank you. Agent Ludwick, I would remind you, sir, you are still under oath. Ms. Branstad.
To what? You testified that both John and Joel have no criminal history. Are you aware that Joel has a conviction for...
Your Honor, I believe that's an objection, misstates the record. The issue had to deal with violent crime.
Why don't you approach, counsel? And again, please.
You testified that neither of the Followells had a history of violence. Were you aware that Joel Followell has convictions for harassment, 4 assaults, 2 domestic assaults, and burglary second?
Yes, ma'am, I'm aware of that.
And that John Followell has at least 2 convictions for assault?
I remember he had assaults on his record, yes.
Yesterday we talked about the gun retrieved from Roger Shin's house.
Yes, ma'am.
Did you take a look? Was it in fact a gun that had capacity for 6 cartridges and had 4 loaded in it?
From the information that I recall, that gun does have capacity to hold 6 plus 1 in the chamber, but at the time that we took it, it only had 4 live rounds in it, as I recall.
And Roger Shin said that's how he received it.
I don't recall what he told me on that day back in 2015.
There's been some discussion about a sprayer. You're aware that Bill Carter sprayed fields prior to the photographs of the Zerts.
That's correct. That after the homicide, when Bill Carter returned back to the crime scene with his family, he was looking at the fields nearby that you could see from the residence, and he could tell that there's an area that Jason had missed. And Bill Carter hops in the tractor, goes down that road, and he sprays that small area of beans, and he comes back, and I found that to be true, yes.
That's not in any report either, is it?
I believe it's in the audio recording of when I take Bill Carter and D.W. Lane out to the Zerts, and I'm educated at that point on Zerts by them, and that's audio recorded, ma'am.
Actually, when you were making, well, at the time you didn't know you were recording that, did you?
I believe it was. If I have a pocket recorder, and I believe that was purposely done because at that point, Bill Carter was still on our radar. D. Lane, his wife, was on our radar. So I would purposely have been recording any interaction I had.
That's a recording that ends with you saying, with the statement, "You're not recording, are you?" and it ends there, correct?
I don't recall that.
You haven't reviewed that?
Not in many years.
And in fact, that is the interview in which you characterized it as, "We've got Bill," didn't you?
I don't recall that statement. It's,
You
it's,
recall saying your only concern was that he's going to flip
regarding who?
Bill Carter.
Bill Carter, the father, or Bill Carter, the son?
Bill Carter, the father.
Earlier in that week, we had been berated multiple times by Bill Carter because he felt that we were not, he didn't understand the evidence-based and suspect-based type of investigation. He was very mad at me personally. He was mad at the sheriff. He was mad at the DCI. He was mad at Marion County because we were wasting the time on his family, and that his family had nothing to do with it. I was not providing case facts to Bill Carter at that time. He was a suspect still at that point. So Thursday, after the homicide, Bill Carter goes into, we are requested to meet with him at his attorney's office.
Your Honor, at this point, again, we've become narrative.
Ask another question, please.
That was the interview in which you said, "We've got Bill. My only concern is he's going to flip." Right?
I do not recall that. I would be glad to listen to it, and I don't remember who I'm talking to or who that recording is with, but
Your Honor, may we
did-
have the witness approach and listen to the recording?
You may. Ms. Branstad.
That recording ends with you talking about, "We've got Bill. My only concern is he's going to flip."
I do make that statement to Sheriff Sandholm, yes.
And then the question is, "You're not recording, are you?" And the recording ends.
I didn't hear that. But it's very possible I said that, but.
No
I-
further questions.
Mr. Bull.
Special Agent Ludwick, I want to start with one of the ending questions that you were asked concerning the weapons located at Roger Shin's.
Yes, sir.
Okay, so if I understand the defense's argument, their belief is some burglar took their own .270 rifle with them to 132 Perry Street, shot Shirley Carter, and then also took a .270 rifle from the basement out of a dimly lit room safe, right?
Objection, and I'm not even sure what the objection is, but I think that it's argumentative that the state is asking this witness to interpret what the defense's contention is.
Sustained.
Why do you find, let me ask it this way, what is the problem with the analysis that Roger Shin has a different .270 rifle, if you know?
The .270 rifle that we took from Roger Shin is a pump style and not a bolt action.
And is it match the serial number of the weapon known to be stolen from Bill Carter's home on the day of the homicide or taken?
It does not.
So let's give the jury a little context. Could you introduce yourself and tell them what you do?
My name is Mark Ludwick. I'm a special agent with the Iowa Division of Criminal Investigation with the Iowa Department of Public Safety.
What does the DCI do?
The DCI has multiple different divisions within our unit. I'm assigned to the Major Crime Unit, and the Major Crime Unit is at the time, we had 5 agents in the Des Moines office, and we will go to assist any local or county or other state agency that they are requesting assistance with a major crime. So we can bring our resources and our experience and knowledge into them to assist them in a difficult investigation.
How long have you been a law enforcement officer for?
I graduated the Iowa Department of Public Safety Law Enforcement Academy in October of 1997.
And before you became an agent with the Major Case Unit, what did you do?
I was a Capitol Police officer under the Iowa State Patrol, assigned to the Governor's Mansion and State Capitol for 2 years. And then I was promoted to Gaming Enforcement Officer in the DCI. And essentially that was a primary law enforcement officer at a casino in Osceola, where we did primary law enforcement anywhere from OWIs to frauds or drug investigations.
And then where did you go from there?
In 2006, I was promoted to the special agent position. I was assigned to Prairie Meadows Racetrack and Casino in Altoona, Iowa, where I primarily investigated horse-related crimes and fraud in the illegal or in gaming investigations inside the casino.
Now, you briefly explained that DCI has these agents. How did they get to rural Marion County on June 19, 2015?
Shortly after the crime, Jason Sandholt had received a phone call from the defendant, and from that phone call, he knew that this was a probable homicide. And this is the first time that I'd been on scene as quick as I have been after the crime was committed. And Sheriff Sandholt then places a telephone call to our special agent in charge and requests the DCI to respond.
Now, when DCI comes in, do you folks take over?
We don't, and that's people don't completely understand that. We come in to assist that agency. We don't come in and say, get out of the way, local law enforcement. We assist them. We're a team, and we bring in manpower and expertise and knowledge and resources that a smaller agency does not have. But we generally work side by side, and we try to pair up when we do interviews. We try to have that local law enforcement officer and one of us. A lot of times that's to our benefit in many different ways, but primarily when we come in, while I was born and raised in a small town, I understand the small town philosophy and mentality. They look at me, I'm just a suit from Des Moines. And so I want that local law enforcement present because they know the names. They know who runs with who. They know any individuals that were names are coming up right away. And I don't have to go do that additional research at that point. At the same aspect, there may be individuals, especially in this case here, they don't like local law enforcement. They don't like the local prosecutors. So it's a benefit that they want to talk to me versus local law enforcement potentially.
Now, during the course of your direct examination with Ms. Branstad, you referenced the name Reed Caius quite a bit.
I did, yes.
Who is Reed Caius?
Reed Caius is now a detective with the Marion County Sheriff's Office. On June 15th, 2015, he was a patrol deputy. He's a fairly young deputy, and but he inspired to be a detective. And at the time when Shirley Carter was killed, Marion County did not have any detectives assigned for criminal investigations. They came up with the funding and position, and Detective Caius was promoted to the rank of detective, and then he's conducted many interviews for me, and he's conducted many investigative courses through the past 4 years.
Sir, when conducting an investigation, do you have a general philosophy on how to organize and prioritize leads and information?
Yes. Well, depends on the type of investigation, if we're going to do a evidence-based or a witness-based. In this case, this is a evidence-based investigation. We start at the body. We start from the get-go. In this case, it was the 911 call. That was the first alert to law enforcement that we had a crime. So we start there and we work out. Anytime homicide, rarely do we find an individual that has no ties to the victim.
Objection, Your Honor. At this point, it's outside the motion in limine. It's improper commentary.
Ladies and gentlemen, you should disregard the last comment made by the witness. Please move on, Mr. Bull.
Sir, you were discussing evidence-based. Can you just explain to the jury evidence-based?
So in evidence-based, we want to look at the evidence. What is the evidence telling us as an investigator? How did Shirley, in this case, how did Shirley Carter die? So one of the first pieces of evidence that came to my light was the 911 call. And I wanted to listen to that call because the 911 call has a lot of information in it, and it was very valuable to me.
Objection, Your Honor, again. We're outside the motion in limine.
Your Honor, may I respond?
You may ask another question.
Sure. And Your Honor, if you believe this question is improper, I'll move on. But did you listen to the 911 call before you arrived?
Objection.
That's a yes or no.
Yes, I did.
Do you frequently do that?
Yes, I do.
Now, moving past the 911 call, when you say evidence-based, and then I think you also said witness-based, and previously you said suspect-based, what's the difference?
Well, when you have a non-evidence-based investigation, we're looking at individuals. If we believe my child was killed by a bear, well, what's that tell us? So who's a suspect? The bear is. So we're going to investigate that. That's not a crime. That's an accident. So evidence, we follow the evidence. If it's a subject base, then we're following that suspect.
Sir, when you arrive at 132 Perry Street on June 19, 2015, did you know anyone who lived there?
I did not know.
On June 19, 2015, by just looking at the crime scene, were you certain who committed the crime?
No, we were not.
Is that why you do an investigation?
Yes.
On June 19th, did you conduct any interviews yourself?
I only conducted one interview myself that day. As a case agent, I'm assigned that case. So while the case agent has a fancy title, it's really more of a case manager. I'm managing all the leads that are coming into me. And when I arrived on that scene, I'm bombarded with information right away. And I'm still assessing the scene and trying to preserve any evidence that may have been missed by local law enforcement.
Your Honor, I think we've become narrative. I'd ask that we proceed in question and answer form.
I would agree. Ask another question.
Sir, you were discussing for the jury when you arrive, you're bombarded with information. What do you have to do with that?
I have to process it. I have to triage it. What's most important right now, and what can I deal with 10 minutes from now, an hour from now, a day from now, a week from now.
Can you explain then why you didn't interview Jason Carter or Bill Carter that night?
I knew I had multiple agents responding from Des Moines area. I knew that when they were going to be arriving, and I don't have the luxury of doing the interviews. I have to assign those interviews out. So I had our agents pair up with local law enforcement, and I requested to have Jason Carter and Bill Carter interviewed first.
Over time, during the course of this investigation, did that manager role change?
Yes, it did.
Can you explain that for the jury?
Over time, as you know, generally the first rush of information comes in that first 48 hours. That's when we are trying to get as much information as adequately as we can, as quickly as we can. After the time investigation goes on, we all of my coworkers, we all have our own caseload. We all have other cases and investigations ongoing. It's not like we just have one case and we sit and wait for the next case to be assigned. We have different ones, and sometimes cases get busy and sometimes they don't. So we have all hands on deck, because this was a whodunit investigation. So we had all of our agents assigned to work on this case. I was the lead agent, so I was managing the leads and assigning them out. And then those agents would report back to me. And at some point, they go back to their normal cases, and then I take over the role of conducting interviews myself or assigning them out still.
And when you say, as it relates to this case, assigning them out, that eventually became Reed Caius's role.
Yes. I felt very confident, especially as time goes by. He was a young deputy, a young detective, but he's very competent and he's a strong detective. And I felt comfortable that he could conduct a lot of these interviews himself. There may be ones that he wanted me to do or we do together, and we would work that out and get that done.
Just from a standpoint of speed, if a lead comes in, is it easier for the local guy just to go out and do it than you come down from Des Moines?
It is. My office is in Des Moines, so that's a good hour, 20-minute travel time. And if it's a lead that he is able to do, I would rather him do it to save for efficiency of the case.
Sir, during the course of this trial, we heard from people from the crime lab and then both crime technicians and then forensic scientists like Vic Murillo and Anna Young. Is there time delay between when evidence is submitted and when reports come back?
Yeah, this is not a TV show. It takes a lot of time for evidence to be submitted and processed. In normal cases, because of the DCI has such a strong inflow of evidence into the crime lab, law enforcement is restricted to submit 10 pieces of evidence per case, and that's a policy of the DCI. In this case, I submitted a lot more than 10 pieces of evidence, and that takes a request, and it goes chain command. But this case is important to ensure that we have the right individual responsible for this crime, and I was allowed to
Objection, Your Honor, both as to improper opinion and, again, becoming narrative.
Why don't you ask another question, Mr. Bull?
Sir, as it relates to this case, Ms. Branstad handed you, before you started to testify, a number of three-ring binders, didn't she?
Yes, she did.
And I think in front of you, as you're testifying right now, there's two-ring binders on the desk that are ledge that I can see. Are there additional binders you have within your wingspan?
I have another binder, and then I've got another stack of papers.
Does even that paperwork printed out reflect the entire Division of Criminal Investigations report in this case?
Does not even come close.
Is it half?
No. Probably an eighth.
So when you're asked questions about what leads did you follow up, is this part of the paperwork that's created from the work that you did?
Correct. Just a small portion.
How many witnesses do you believe have been interviewed in this case?
A lot. I'm going to guesstimate over 200.
Sir, we heard a lot about what I'm going to generally refer to as alternative suspects, okay?
Yes, sir.
I think it's important that we understand the time frame. In June of 2015, were there any alternative suspects that came to light?
Not from anyone other than Jason Carter.
Okay. So let's take a step back and discuss that. On June 19, 2015, Jason Carter was pointing you in the direction of individuals.
Yes. Within minutes of me arriving on scene, I was handed a letter from a local civil attorney of Jason Carter, and Jason Carter was directly pointing Michael Mcdonald as a person of suspect who killed his mom over a land dispute.
As a result, did you attempt to ascertain where Michael McDonald was on June 19, 2015?
Yes. That was one of the first leads I assigned, was locate Michael McDonald and get him interviewed.
Did that happen?
Yes, it did.
And Mr. McDonald is someone who Jason Carter had previously rented land from.
Correct. He had previously had a rental agreement with Mabel McDonald, who had been Michael McDonald's mother. And Mabel McDonald had passed away, and then Michael McDonald became owner of that property, and Michael McDonald intended to sell it and did not.
Objection, Your Honor. Now we're into hearsay that's not related to the matter.
Your Honor, my understanding from the court's ruling was that the state was allowed to explore hearsay statements that prove what it was that law enforcement did to disprove the defense's theory that this was an inadequate investigation.
And I agree, Your Honor, I only objected once it crossed the line outside of that investigation.
All right, and ladies and gentlemen of the jury, I would simply again reiterate the admonition I gave you. These hearsay witness statements made to peace officers during the course of their investigation should not be considered by you for their truth. Rather, you may simply consider these statements for the purposes of determining whether law enforcement officers properly conducted their investigation. You may proceed.
Sir, as a result, to determine, could you explain what you did to properly investigate the lead of Michael McDonald?
We located Michael McDonald. We had ascertained his whereabouts and where he had traveled that day, where he had been, who he had been with. Mr. McDonald gave us his phone. Mr. McDonald cooperated with an interview and anything else we asked of him. I also, that evening of the crime, I had the opportunity to call the civil attorney. The civil attorney represented both parties. So this attorney represented Jason Carter and also Michael McDonald. And I want to know, is this truly a heated argument? Is this a heated debate of the land? And the attorney simply said, it's not. I represented both. I told Jason Carter, he wants you off the land. This is the agreement. If you guys can't agree to this, you need to go your separate ways, get your own attorneys, and then proceed. But I'm not going to represent, I can't represent both clients if this is going to be heated.
And as you continued to properly investigate this lead, were you able to determine whether or not Michael McDonald had ever met Bill or Shirley Carter?
No, to our knowledge, he has not.
In July of 2015, were there any alternative suspects that came out from the public?
No, there was not.
In August of 2015, were there any alternative suspects that originated from the public?
No, there was not.
In September of 2015, were there any alternative suspects that came to light?
In September of 2015 was the first time that Joseph Sedlock came to light, and Joseph Sedlock gives his stories of the homicide. while he was in jail, asking to get his kids placed back into his custody because the DHS was permanently terminating their rights, and he was facing prison time, and he was asking for a deal for the prosecutors.
Now, I want to talk about the first interview that Joe Sedlock gave. Who did he speak to?
He spoke to a local task force narcotics officer with the Knoxville Police Department.
How long was that first interview?
About 70-some minutes. Most of that interview was all narcotics related. The task force officer listened to him. The task force officer wanted to gain information from him, but he was not giving any credible information. That task force officer essentially was like, "See you, Joe. I'll arrest you next time." Or he had no credible information. And as a task force,
I think it's becoming narrative. Mr. Bull, please move on.
After the task force officer indicates goodbye, is that the first time Joe mentions he has information about the homicide?
that's correct.
Sir, have you had an opportunity to listen to the audio recording of who I believe you've described as Lieutenant Corey Derby with Joe Sedlock?
I have. It's been a while since I've listened to it, but yes, I've listened to it.
Does Lieutenant Derby inadvertently provide case facts to Joe Sedlock?
He does, yes.
Can you explain to the jury, if you recall, how that happens?
I believe Derby accidentally or tells him, are you talking about Shirley Carter? Are you talking about the female down in Melcher area? And tells him that there's a rifle involved. And this was before he called me.
Do you, in fact, then immediately upon learning this information, the very next day go interview Joe Sedlock?
Yes, we do.
In that first interview with Joe Sedlock, does he provide information that's inconsistent with the crime scene evidence?
Yes, he does.
Can you give the jury some examples of that?
Well, he tells us that Joel Followell told him over a month ago. And if he had that information for a month, why did he not come forward right away? And why was that not the leading piece of information to get cooperation from prosecutors? He tells us that it was a .22 handgun, and then changes, well, it could have been a rifle, it could have been a .22 rifle. And at that point, a .22 rifle is a very small round, approximately the size of a pencil eraser. And we knew that that .22 round was not involved in the homicide of Shirley Carter. He gives us a lot more information that I felt that he was not being a credible witness to us.
How many additional times was Joe Sedlock interviewed by either you or Reed Caius during the duration of this investigation?
I believe it was a total of 7 times, so 6 additional interviews with, and that's not including phone communication or text messaging between me and Joe Sedlock.
Did Joe Sedlock's statement evolve over time to include additional information?
It did.
At some point, just so that we're completely clear to the jury, Joe Sedlock finally lands on, it's a .270 rifle.
He does, yes.
That sounds like it's probably a pretty big clue, isn't it?
It is, and we were excited. He said he can get me that .270 rifle. As we investigate that further, Mr. Joe Sedlock was also represented by an attorney by Mr. Conrad, a local attorney that represented Jason Carter, hired by Bill Carter on June 22nd, 2015. And Mr. Conrad,
Objection, Your Honor.
Why don't you ask another question, counsel?
Sir, did you in fact confront Joe Sedlock with the fact that he didn't independently know it was a 270?
that's correct.
And was it in fact that Joe Sedlock conceded he learned that information from Robert Conrad?
Your Honor, I would object on two grounds. One, this has become leading, and additionally, with regard to any of the commentary about the communication with Robert Conrad.
Why don't you rephrase your question? And Mr. Bull, I think it is appropriate for you to use non-leading questions in your examination of Agent Ludwick.
Sir, what did you learn about how Joe Sedlock figured out at the end it was a 270?
Objection, Your Honor. May we approach?
You may.
Sir, I'm just going to cut to the chase. Joe Sedlock learned the weapon was a 270 from Robert Conrad, didn't he?
That's correct.
Was the fact that Joe Sedlock knew it was a 270 now as big a lead in your mind?
No, not at all.
Now, we also mentioned yesterday, and some this morning, an individual by the name of Matt Camerick. Do you remember being asked those questions?
Yes,
Sir, do you feel comfortable that you know where Matt Camerick was on June 19, 2015?
I do.
Based on the information you know, where was Matt Camerick?
Matt Camerick had a court appearance at the Marion County Courthouse on that afternoon of June 19, 2015, and he had met with his attorney previously to that hearing in Knoxville, Iowa.
Now, does that necessarily prove he wasn't somewhere else in the morning?
No, it does not.
Why do you give that weight?
I find it highly unlikely that Matt Camerick, one, is capable of.
Objection, Your Honor.
Let me
Test
rephrase the
relevance.
question, Your Honor.
Please do.
Sir, without discussing your beliefs as it relates to Matt Camerick's personality or abilities, what was it about the fact he was at court that afternoon that was important to you in an investigative standpoint?
I found it unlikely if he had committed a burglary.
Objection. Same question.
Sustained.
Sir, has Matt Camerick cooperated during this investigation?
Completely and fully, yes.
Has he provided statements to you that are contrary to his criminal interests, for lack of a better term?
Yes, Matt
Objection.
Camerick,
You've answered the question. The answer was yes. Please ask another question.
How was it that you got to Roger Shin?
Matt Camerick is a felon, and he told us that he had weapons in his possession, and he sold them to Roger Shin. That in itself is a crime. He just
Objection. Again.
And what is your objection, counsel?
Your Honor, at this point, it's outside, it's become narrative.
Ask another question, Mr. Bull.
Sir, when you've indicated that he stated he sold the weapons, why would that be against his interest?
because that I could charge him with a felony as a crime.
Sir, and I think the jury already has heard this from another witness, has DCI or any member of law enforcement found Bill Carter's .270 bolt-action rifle?
No, we have not.
Now, if that gun were to be pawned in the state of Iowa, would you know it?
Yes, we would.
Can you explain why that is?
anytime a gun or vehicle is registered stolen, is entered into a national database. We call it NCIC computer, National Crime Computer. So that serial number is entered in as stolen. So anytime a pawn shop would have a transaction regarding that serial number, we would get a hit. And that hit has the stolen gun description and serial number that was potentially used in a homicide investigation, and then it has my information and case number to make contact with us. And that's national, and also goes into Interpol databases. So if it is sold in a gun shop or a pawn shop or through an ATF dealer, we would get hit on that. Now, if I had that gun and I sold it to my brother, hand to hand, that would not generate a hit because there's no legal documents or searches conducted on that.
Okay. So during the course of this case, has the DCI received information that this gun was pawned?
Yes, we had.
As a result of how you understand the system works, if a person comes forward and says, I know Taylor Marshall pawned that gun, or excuse me, Taylor Jones pawned that gun at a pawn shop in Des Moines, do you give a lot of weight to what that person's telling you?
At that moment, I do, but once we check the pawn records and pawn records, pawn shops have to ID the person bringing in an item for pawn. They have to register. They have to, if it's a gun in this case, they have to run it through NCIC, and I checked that. We checked the pawn shops not only in Iowa, but we later found out through under oath that it went to Missouri. So we checked the Missouri databases, and there's no record of that gun in any pawn records. And we did find that Mr. Taylor.
Hold on, let me, just so we don't get, we can just keep our conversation going here. At some point, yesterday we heard the name and it's Taylor Jones, correct?
Yes,
And you received information that Taylor Jones had pawned this gun.
we did.
Now, you've already told us the gun hasn't been pawned, but does Taylor Jones pawn stuff?
He does, but no firearms.
Did you in fact research what items Taylor Jones had pawned over the last X number of years? Tell me how long you went back.
He went back prior to 2015. I don't remember the exact dates that we searched, but we searched the records in its entirety, and he had no firearms at all that he had pawned.
Now, we've already mentioned very briefly the issues related to Lieutenant Derby inadvertently providing case facts. Is it safe to say that law enforcement's the type of career that can get Monday morning quarterbacked all day long?
Objection, argumentative.
Overruled.
Yes,
Do you even Monday morning quarterback yourself?
absolutely. On every case and almost all my interviews and investigations.
Always wish to ask a different question or phrase it slightly differently?
Objection as to leading and relevance.
I think it was leading. The witness answered. Please move on.
Sir, specifically as it relates to Shirley Carter's case, was there information released to the public at various times?
Yes, there was.
Can you think of information that the Marion County Sheriff's Office released to the public?
In July of 2015, they did a press release because they were being constantly inundated with media questions, and they released that we were looking for a rifle in the connection of the homicide of Shirley Carter.
Now, that still didn't stop people from telling you a handgun was used.
It did
Objection
not.
as to leading.
Did-
It was.
did-
He has answered.
Do you know why the sheriff's office, and if you don't, that's fine, why they put out that press release?
I don't recall at that time what the thought process was.
We also heard yesterday, during your questioning, that some information was relayed by Krista Norris that Mr. Sedlock and the Followells were scoping out Bill and Shirley's home and knew their routine to go get coffee. Do you remember that question?
I do, yes.
Do you agree that that appears to be a fairly significant piece of information?
At the base of that question, yes, it's very informational, interesting to me. However,
What's the rest of the story?
at that time that we learned that, the defense had released hundreds of documents to the media, and the media picked up on all of that. And the media releases all these names on behalf of the defense.
Objection, Your Honor. I think that it's an incorrect statement of the record. And, well, I'll cover that in cross. I withdraw my objection.
Ask another question, please.
Sir, if you were to just simply Google Bill Carter homicide, what stories would come up on the front page?
Objection, Your Honor. I think this is beyond the scope and really may we approach?
You may.
Sir, was the fact that Bill and Shirley got coffee in the morning a generally known fact based on media coverage?
Yes.
Sir, you were asked yesterday about statements you made to Jana Lane. Do you remember those questions?
Yes, I do.
Sir, as a law enforcement officer, are you allowed to provide misinformation or lies to people you're interviewing?
We are allowed to.
Did you intentionally do that to Miss Lane?
No, it is my general practice. I try not to do that. While there are times that I have in the past because of certain circumstances of that individual or that investigation. But in this case, there was never a time that we purposely gave false information to a witness or suspect or subject that we were conducting an interview with.
Can you tell us what happened as it relates to the bullet in the bottom of the safe?
That interview with Jana Lane was on the late evening of Monday, the 22nd. And on Monday morning, we had been summoned to the crime scene by the family. So we met with the family of Bill Carter, Jana Lane, Jason Carter, and his wife, Shirley Carter. And they were quite upset with us. And they let us know what their true feelings were with us at the time. And we then go into the house and we note that they had found a lot of evidence that morning or the day previously too. One of the pieces of evidence that we were taken down to the basement of where the gun safe was at. And this is a pretty dark, small storage room in the basement. And I did note there is a bullet, a live cartridge, in the lip of the door near the locking mechanism. And I find that at the time, I'm like, how did we miss this? How did our crime lab miss this? And I questioned myself, did we miss it or was it placed there after the fact? The day gets very busy pretty quickly.
Did you have a conversation with the Criminalist about that?
I did. At some point during the day, I call him and Michael Halverson, which I believe he's testified in this case. He was the lead crime scene criminalist at the scene. I asked him to pull the photographs of that. I said, I need to know, is that bullet was it in the lip of the door at the time that we processed that crime scene? And the information provided to me was, no, I don't see it. Now, so I was acting on that behalf that there is no bullet. So at that time, I was concerned, do we have a scene that's been tampered with by family at that point, or did we miss it? And I believe at that moment, it was a tampered scene.
Now, Your Honor, may Mr. Robinson approach to retrieve some evidence? He knows where it is better than I would.
He may.
While Mr. Robinson is doing that, were you also made aware that on that same time frame that Jason Carter located what he believed to be a substantial piece of evidence?
Yes.
Can you explain that to us?
He made this big production that he found this bullet, this big bullet in the wood. Again, I'm thinking, how can we miss a major bullet? Do we have 3 rounds? Do we have 4 rounds? And he had dug out that bullet that he had recovered.
May I publish 146 to the jury?
You may.
Sir, as we're waiting, did you attempt and retrieve that evidence from Mr. Carter?
I did retrieve it and I photographed it while it was, the family had placed it on the cupboard in the kitchen, and I photographed it there in its place, and then I collected it that day.
Is that what he found?
Yes, and that's also enlarged through the Elmo itself.
Your Honor, may I show it to the jury?
You may.
So Jason Carter knew exactly where this was.
He did.
Objection. As to argumentative, I believe the statement previously was just that Jason Carter found it.
Overruled.
That's what
Sir, we also heard evidence yesterday that Matt Camrick and one of the Folwells left in Michelle Daniels' white or Kia SUV. Do you recall those questions?
I do, yes.
And is it fair to say that Miss Daniels provided tremendous amount of depth and information concerning that?
Yes. At some point during the interviews, Ms. Daniel was confident that her vehicle was used at the crime scene to transport the individuals to the crime scene and away from the crime scene after the homicide took place. We took great interest of that. We wanted to track that down. That was a lead we followed up on right away. We learned that that vehicle in question was impounded the night before by Marion County Sheriff's Office and remained in the impound lot for several weeks after that homicide of Shirley Carter.
And isn't also the connection that when Matt Camrick sells the guns to Roger Shin, Matt Camrick uses the money he gets to get the car out of impound?
That's correct, and those dates correlate.
We also heard information that did Michelle Daniels, while also telling you she was certain her car was used, also provide information about Rory Pearson's role in this case?
She did, yes.
And if you recall, did it involve Joe Sedlock showing up at the home to get Rory Pearson after the fact?
Objection
Yes,
as to leading.
Overruled. The witness has answered.
What was your understanding of when it was Joe Sedlock and Rory Pearson left the home to go to 132 Perry Street?
As I recall, Joe Sedlock comes to the residence to pick up Rory Pearson, and that they go back to the crime scene afternoon of the crime because they have to clean up their mess. And we know that not to be valid information because multiple law enforcement officers were on scene prior to 11:30 and remained and on that scene. We had custody of that entire scene until late Saturday afternoon on the 20th of June 2015.
Your Honor, I'm wondering if perhaps we need to replace Special Agent Ludwick's battery, and it looks to me that my battery needs to be replaced as well.
Help is on the way.
You should be good to go.
Sir, at some point during the course of this investigation, the issue of a Kia SUV comes up multiple times, doesn't it?
It does.
And so, at first glance, the fact that we have Ms. Daniels saying, I think my SUV is being used, we did have a report of an unknown Kia SUV in the area.
We did that day.
Were you able to run down who that person was?
We were. It was Miss Monica Friday. It was Ms. Monica Friday.
And you spoke about Miss Friday, at least in part, this morning. What were you able to determine from Miss Friday?
Information came that an individual was hiking across the state of Iowa. And during that hike, he was in the area from Milo to Pleasantville, which is in the area of the crime scene, but not close. And during his hike, 2 dogs started following him. So when he got to Pleasantville, while he enjoyed the dogs reportedly, he didn't want the dogs to leave the area with him. And there was a Monica Friday, who is a known animal advocate. So she took custody of the dogs, and she was driving around the area going farm to farm and trying to locate the owners. And there was Facebook posts on there that we were able to secure that validated that information and that story.
You were also asked about an individual named Charity Roush yesterday, were you not?
Yes, we were.
Now, the jury heard that Joe Sedlock made some statements to her.
Yes. Yes, that's true.
Can you tell us what else Ms. Roush said that gave you pause when evaluating the credibility of her statements?
None of it made sense. None of it met the evidence-based investigation. Information that she provided was that they were already in the house when Shirley Carter came in the house, and that they were in the kitchen going through the cupboards looking for medication or drugs. That just does not make sense. And further by that, the follow-up boy accidentally shot her. The gun accidentally went off. If that would have been the case, Shirley's body would have been in front of the door, not between them and the kitchen.
Objection, Your
Information-
Honor. At this point, the witness has begun to speculate and is providing an improper opinion.
Well, to the extent that the witness has provided his own opinion, ladies and gentlemen, I would ask that you disregard it. As I previously indicated to you, statements made to the investigators during the course of their investigation should not be considered by you as true. Agent, I'm going to give you this mic.
Thank you, sir.
Try it out.
Testing 1, 2, 3.
Okay.
Your Honor, I hate to do this, but may we approach it? Perhaps it's a good time to take a lunch break. I just have a legal issue I wish to bring up.
Well, ladies and gentlemen, as long as we're taking a break, why don't we take a long break? We are going to have our noon recess. Please remember the admonition that I've given you repeatedly during this case. You need to keep an open mind. You have not heard all of the evidence. Please do not discuss the case among yourselves or with anyone else, including family members or friends that you might encounter over our noon recess. Please do not allow yourself to be exposed to any media reports related to the case. We will reconvene at about 5 after 1.
I think it's when you turn your head to look, if you just try to straight look, I think that's what it's happening.
Mr. Bull, does this need to be on the record?
Yes, Your Honor.
Okay.
Your Honor, I just wish to be heard concerning the defense's last objection. Specifically, may I be seated, sir?
You may. Please do.
The witness is now explaining why it was that the information that was provided did not meet the evidence seen at the observed at the scene. Specifically, the objection was as it relates to Special Agent Ludwick, and I'm not certain that the words he used. I'm sure you do, as it's in front of you. But, Judge, if we have a statement that says people are in the kitchen or other areas disturbing, going through drawers, she walks in and she's shot, I'm not certain how it's an opinion with the fact that both the defense's expert, Dr. Etch, and the state's medical examiner both indicate the first shot is from her right to her left. And so when we have a conversation about how the crime scene doesn't match one of the stories that's being told by law enforcement, I think there's one of two questions. The first is, it's a fact, it's not an opinion. But secondly, if the defense doesn't want the witness to answer it as a fact, then I'm not certain how the lead investigator of this homicide case could not be offering an opinion as to why he believed the evidence doesn't match the scene. So I would ask the court to reconsider its ruling to the extent it's sustained. I'm not certain whether or not you said sustained or told me to move on. But, Your Honor, I just want to be clear moving forward as we dissect each and one of these statements and individuals that the law enforcement officer is able to explain why what is said doesn't match the crime scene.
Ms. Branstad?
Your Honor, I think there is a difference between saying, this witness said that Shirley was, well, I'm going to use a less, there's a difference between a witness who says, this occurred at, in the bedroom, and then saying, we have photos that Shirley Carter was found in the kitchen, and saying, well, this doesn't make sense because, and then doing an analysis and presenting an opinion as to why it doesn't make sense. There's a difference when it is speculation as to what would have occurred also. Because I think he's getting into if then. Well, if that would have been true, then this is the evidence we would have seen. That is, in that case, speculation, and some of it is invading the province of the fact finders as well.
Well, and I guess I tend to agree with that analysis to a certain extent, Mr. Bull. It seems to me that you can ask the question, did you find statements that were made by this witness to be inconsistent with the facts that you knew to be true? Yes, I did. What did the witness tell you? The witness told me this. How is that inconsistent with the facts at the scene? As far as this particular, and the witness can then say, well, she was found in the bedroom rather than the kitchen, or the kitchen rather than the bedroom. But for the witness to go further and say, well, she was shot through the right side, and that means this, and that means that, those are facts not even in evidence by anyone.
Well,
As to the location she was standing when she was shot?
I would disagree with the court's, Your Honor. We heard Special Agent Criminalist Halverson talking about the rods and positioning, and we heard the defense's expert yesterday indicating she was shot on the right side and the shooter was standing by the door.
And the rods and the positioning are in evidence?
Yes.
Okay.
And I don't think that our expert said the shooter was by the door.
I believe it's the second question I ask of the things we can agree about. Where was the shooter standing? By the back door. Do you agree she was shot? Shot twice. Where was the shooter standing? Shot by a rifle. Those are the questions we can agree upon. And your expert said yes, 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 yes.
It seems to me that the witness can be asked, what are the facts she told you? What were the facts you found to be true?
Okay?
Okay?
Yes, sir.
Without getting into this witness's analysis, that's argumentative, that's reserved for closing arguments.
And, Your Honor, I would also ask that the witness refrain from saying, and the questions refrain from specifically making a finding that a witness is credible or not credible. I found that witness not credible because I think that specific opinion crosses the line also. I think they can talk about the contrast in opinion, but not specifically say a witness is not credible.
So what I understand is the statement is not credible, but that doesn't reflect on the person who provides the information.
Or the statement was not correct. As opposed to, I didn't find this witness to be credible because.
Well, but isn't this entire discussion the defense wants to have is they didn't follow leads. So as a result, why should the law enforcement officer not be permitted to say, here's what I have. This is why we only interviewed this person one time. This is why we didn't go back to this person, because this is the information they told us.
And he may do that.
Okay.
He may do that.
Your Honor, and just to clarify, but without using the words because that person's not credible, I think that there still needs to maintain a statement as to the facts because it didn't line up, not because this person wasn't credible.
I agree.
Understood.
Okay.
Are we released?
You are. Thank you.